We start. Justice Anil Killor and Justice Raj Vakode at the Nagpur bench of the Bombay High Court have dismissed the writ petition filed by Messrs. Himmatlal Agrawal and Shivkumar Agrawal on August 6, 2026 with their verdict that scope of Section 14 of the SURFACE Act is very limited and ministerial in nature. The collector has no power to adjudicate the claim or counterclaim raised in the application under section. The High Court has pointed out that in this context, finality has been given to the order under section 14 of the SURFACE Act is the correct position of law and there cannot be any dispute about the same para. However, in the said judgment, it has not been held as argued by the petitioners that in case of asset reconstruction or assignment agreement, a fresh application will be required at the behest ARC under section 14 of the SURFACE Act. Hence, the judgment of the Union of India versus State Bank of Maharashtra 2005 MLJ 270 is of no use to the petitioners. In this petition, the petitioners have raised a challenge to the legality and correctness of the order of February 23, 2026 passed by the District Magistrate Nagpur directing the Tehsildar Savner to hand over possession of the mortgage property to the respondent Asset Reconstruction Company ARC instead of the respondent HDFC Bank para. The petitioner number 1 is a partnership firm which availed a credit facility from the respondent bank. The properties which were mortgaged against such credit facility are owned by the petitioner number 2 Shiv Kumar. On declaration of account of the petitioner number 1 as non-performing assets NPA, the respondent number 2 bank approached the district magistrate under section 14 of the SURFACE Act 2002. The district magistrate additional collector accordingly passed the order on December 4, 2019 directing the Tehsildar to take possession of the mortgage property in para. Therefore, the respondent bank executed an assignment agreement in favor of the respondent ARC. The step taken by the district magistrate while taking possession of the secured and documents relating to the assets, it is a ministerial step and could be taken by a district magistrate itself or herself or through any other subordinate to him or her, including the advocate commissioner who is considered as an officer of his or her court while disposing the application under section 14 of the SURFACE Act. No element of quasi-judicial function or application of mind would be required. The magistrate has to educate and decide the correctness of the information given in the application and nothing more. Therefore, section 14 of the SURFACE Act does not involve the adjudicatory process. Points raised by the borrower against the secured creditor taking possession of the secured assets para. It is thus amply clear that the district magistrate is duty bound to take possession after order is passed under section 14 subsection 1 of the act and till the possession is taken over. Proceeding under section 14 cannot be considered and treated as concluded. In the circumstances, the High Court has not accepted with the arguments made by the counsel of the petitioners that once the order under section 14 subsection 1 of the Surface Act is passed, the district magistrate becomes functus officio.